The purpose and function of the Jacksonville Beach Special Magistrate hearing in accordance with Florida Statutes, Chapter 162, and the City of Jacksonville Beach Code of Ordinances is to reach an equitable expedition to enforce the codes. The city presents the violation and the evidence to the special magistrate. Next, the property owner is sworn in and responds to the violation evidence. Both the city and the property owner may call witnesses to provide sworn testimony relevant to the case. This is a quasi-judicial hearing, not a public forum. Individuals not called as sworn witnesses will not be heard. And I'm going to make an announcement. If you are going to speak or be brought up to provide testimony, I'll need you to stand and raise your right hand. I'm going to go ahead and swear you in. When you come to the podium, you'll state your name and address for the record at that time. So if anybody's here and they will be speaking for their case, if you could stand up and just raise your right hand for me. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good afternoon. My name is Wayne Flowers, and I serve as Special Magistrate for Code Enforcement for the City of Jacksonville Beach. We're going to be conducting these hearings in a few minutes, and as a matter of procedure, the Code Enforcement Officer on each individual case will make a presentation. Then you will be given an opportunity to speak and offer any evidence that you intend to offer in this proceeding in regard to the matter that you're here for. So with that, Ms. Beavers, are we starting with 21-308?
Yes, this will be Duval Royal Investments in Tallow Bistro. The address is at 798 South 3rd Street. This business was cited for prohibited signs. Several verbal warnings had been given in regards to the banner sign that was up when the business first opened, and then also there was several A-frame signs, as you can see on here, when the case was initiated in April for the A-frame signs being out on the city right-of-way. I did speak to the business owner on numerous occasions to advise him of the violation of the prohibited signs. They continued, and we are here today to ensure compliance. They have come into compliance as of today. So my recommendation today would be just to ensure that compliance is maintained.
So you said an apron sign, is that what you said, A-P-R-O-N?
The A-frame.
A-frame, I'm sorry, I couldn't understand what you said. What's an apron sign?
Yeah.
Okay. Anything else?
That's it.
Okay. And could you state your name, please?
It's Joseph Brown. Joseph Brown.
Joseph Brown?
Yeah.
Okay, Mr. Brown, you have something you'd like to share with me?
Just wanted to apologize and tell you that it's we had corrected the issue after we realized what it was, and we were just obviously just trying to be as aggressive as possible to bring in as many guests to our business, and we understand why the policy's out there, and we just apologize for taking your time today. So.
Okay. Well, very good. Thank you for being here. And what I'll do is just simply enter in order, finding that since the notice was given that the sign's been removed, and understanding that compliance will be maintained thereafter.
Yeah, and I would also want to add, if there's any further non-compliance, that if we had to come back before you in regards to the same violation, it would be $250 per incident.
Okay. Anything else, Mr. Brown?
That was it. Thank you, guys.
Okay, well, thank you.
And case 21-308 will be closed.
Okay.
All right, moving on to case 21-313. This is Jesse Michael Boyles at 104 North 10th Avenue, Jacksonville Beach. This is in regards to non-compliance of obtaining a building permit for a driveway and the pavers that were added to the driveway. This case was started back in May of 2021. As you can see, the pavers that are on the right-hand side, Mr. Boyles did obtain a encroachment permit from Public Works for the right-of-way. What he needs to do at this point is to remove the pavers that are 10 feet away from the house. That is actually where his property line starts to come into compliance. Once he removes those pavers, then he can apply for the variance. And from my understanding, a variance application has already been submitted, but it's not considered sufficient at this time until compliance has been obtained.
All right, so again, the paver portion, are you telling me has been permitted?
It has not been permitted, so a
So
building permit.
what has been permitted?
Only the part that was on the right of way. So as you can see on the right-hand side, 10 feet, if you can see where that shadow is from coming from the garage, a little bit up where the line is, part of his driveway, that's pretty much the 10 feet of where his property line starts. The remainder of it would be part of the city right of way. So he needs to remove the part that's 10 feet from the front of the house.
So the ordinances do not permit an after-the-fact application?
No.
And the application will not be processed or issued until?
This is brought into compliance.
Okay.
I've spoken with planning and development, and that was their recommendation. Planning and zoning. So once those papers have been removed, and if Mr. Boyles wants to reinstall them, he would first have to obtain a building permit to reinstall those papers and to also apply for a variance because it exceeds his lot, exceeded the lot coverage for his property.
So he's going to need both a permit and a variance?
Correct.
Okay, and that would be for all of the area, basically somewhere around where that shadow is down to the street?
From where the shadow is pretty much the 10 feet from the house that needs to be permitted. It's a very small portion, but because it was done without a permit, that's why planning decided that it needed to be removed. The remainder of the property was all part of the encroachment permit that they obtained from Public Works.
And again, to understand, when you say the remainder, I'm not sure.
Everything else past the 10 feet from the house to the street is all actually the right of way, the city's right of way.
Okay, but when you say the remainder was permitted, you're talking about from there back to the house?
Yes,
Okay, got it.
I'm sorry.
Okay, are you, Mr. Boyles?
Yes, sir, I am.
Okay.
I made considerable effort to make sure that I was doing the right thing. I made multiple trips down to this city hall where they passed me back and forth between Public Works and this city hall office over and over again. After being passed back and forth 4 or 5 times within one day, I stopped David down at the Public Works office and I said, you guys got to get on the phone and speak to each other and tell me what I need to do. I was trying to do the right thing. I was told all that I needed was a right-of-way permit. I did that. I have all the date stamps here. I brought drawings and showed what I was planning on doing. That was all done back in 2017, well before these pavers were put in place. I then did part of the project in 2017. I finished the pavers in early 2020, which I have proof of that if you'd like that as well. I then came back for the fence that's in the picture there. I came back in October of 2020 to then go through the process again to say, hey, I'm putting a fence up. Is there anything different? Is there anything new that I need to do? Yet again, I was passed back and forth. Nobody knew where I was supposed to go. David eventually over at Public Works came over and said, hey, I'll drive out, take a look at it. He took a look at it. I have all the drawings here, date stamped and everything when I worked at the Public Works office. I got that right-of-way permit. I was then told that everything was good. Then fast forward till March of 2021, I now have a violation after I made a considerable effort to do this. I think it's ridiculous that you're asking me to remove pavers after I made that effort to make sure I was doing everything right.
When you were told everything was good, was that in relation to you were trying to get authorization for the fence at that point? Is that?
I had everything on the drawings, the entire landscape of the whole front yard. So everything was on there, and I questioned everything. You can even see on here in 2017, if I can approach and show you.
Sure.
So these are the drawings that were submitted to Public Works. And while I was going through that process, this is the original drawing. And I said, I'm going to put gravel down first because I don't have money for the pavers. They said, go ahead and scratch that out and put pavers down. You can see the date stamp of Public Works. I then came back in October and said, this is the new adjusted thing. Does anything else need to be done? And nobody said anything. Everyone just said, go to Public Works, go to Public Works. And I'd go to Public Works and they would say, come back here. And so I was tossed back and forth. I mean, I made a pretty big effort trying to make sure I was doing everything right.
Well, let me ask you this, though. What were you specifically applying for when you submitted these plans?
Everything on the drawing. I didn't know what the zoning rules were, codes were. I came down here for advice from my city members, asking them to tell me what I needed to do. And so I said, here's everything that I'm doing. I have the rest of the zoning permit if you want to read more of what the comments are.
Yeah, let me see that.
The pavers were never brought up as an issue until March of 2021.
This permit says that it was only for the fence addition. And at
Correct,
this point-
because everyone said that the pavers didn't matter.
what
Up
was-
until March of 2021, the pavers were never brought up as an issue, and they were on the drawings the entire time. I brought them up and said, this is what I'm doing. Is there anything I need to do special here?
Who was everyone again?
At this front office here, at the two glass doors, the zoning permits, they would always send me over to the Public Works office. And then the Public Works office, the only people that were helpful were Ann Moody and David, I forget David's last name.
And to be clear though, when you got this permit, this is dated May 21st, 2021. The area of the pavers that's in dispute here had already been constructed.
No, that permit was started in 2017. That permit was issued in 2017. I forget the exact date. There was just an update to it in October, I think it's October 30th of 2020.
Okay, this permit that you handed me though has a date on it of May 21st, 2021.
That's because I think they just reprinted it for me. I had to get a copy of it. You can see permit issue date was July 18th of 17.
Okay,
And then you can see the date stamps on the drawings. Here we go. This permit is being amended on October 30th of 2020.
okay. So when was this section of pavers?
The pavers were
When was that
installed early 2020. I can pull it up here.
Your Honor.
I'll give you a chance in a
Okay.
second.
The pavers were installed between January 28th, 2020 and March 13th of 2020, the final payments. And the contractor that did the installation even said that he didn't think there was a permit needed at all, but I should go downtown and check it out. So that's what we did. We went down to City Hall and showed everything that we were doing and that everything was going to be done in this fashion. And March of 2021, I'm now in violation.
Okay. Ms. Beavers, do you want to see any of these?
I've already reviewed the ones that he submitted with the variance.
And before I go to Ms. Beavers, do you have anything else to add at this time?
No, sir. I mean, I'd say that I've done everything they've asked me to do. I've gone and submitted all the variances, and all the construction of this is all done perfect with a contractor, and we have all the basing done right. We have drainage all taken care of. Everything was done to par, and I would just say that having to rip everything up is a waste of money, just so that I can now resubmit a piece of paper that's already submitted.
Mr. Boyles, before you leave, could you also state your name and address for the record for me?
Mike Boyles, 104 10th Avenue North.
Yeah. I apologize, I should have asked you that.
No worries.
It was picked up. Ms. Beavers?
Okay, so, the main issue that I think Mr. Boyles, isn't understanding is that the permit that he was issued from Public Works was permission for him to pave and fence the city right away. That's what the permit. Anything beyond the city right away that goes onto his private property, he would have had to obtain a separate permit from our building department. When it comes to the variance he would apply for would have gave him permission to go over the lot coverage that he has already exceeded for his property. So when it came to him putting the pavers down and the fence, it was only up until the point of where his actual property line started. But he went beyond that and did the entire property without getting permission from the building department. So that's where the issue lies at as far as what he had a permit to do and what he exceeded.
Okay.
That's an incorrect statement, sir.
Hold on one second, you
Yes,
raised
sir.
your hand.
Yep.
What caused the city to become aware of this?
One of our building officials observed another case that we have coming up that it has done the same thing.
Okay.
And that was the building official, and he is here today.
I'm sorry.
And that was by the building official, he's here today.
Okay.
to the permit and variance department in planning and development. Also, the planning director has also been aware and have reviewed the same issues that we're looking at today as far as exceeding the lot coverage.
If I may.
Hold on one second. You're going to be able to speak as much as you want.
Okay,
Just give me
yeah,
one second.
no, I get it.
So in terms of the permit that's been provided to me by Mr. Boyles, where would I find on here exactly what he was authorized to construct?
Only the right of way, only the part, can I take a look at?
Sure.
The part where his actual property line actually began is the part that he exceeded. And from the site plan.
Okay, why don't you go back there, speak from the microphone.
So based on the site plan that Mr. Boyles had submitted to the office, on those site plans, it'll show that 10 feet that is off of the house, that shows exactly where his property line started, and that is the part that needs to be removed.
But again, what I was getting at is in that permit, as far as that permit goes, where does that tell or indicate that what was being authorized was only construction in the area that you described?
Let's see. I don't see it on the documents that he actually submitted, but when it was issued back in on 4/2/15, let's see.
And I understand the pavers were already constructed when that permit was issued.
4215 was not me. I was not the owner of 4215.
Okay, hold on a second.
Do you actually have with you today the survey or the permission of the permit that you received from Public Works? Showing the actual area that they're giving you, that they were permitting?
That was never required. That's everything that they gave me.
Okay.
That was approved. I did issue a full survey with the variance, which is in the office right up here.
I understand, but what I'm trying to understand, I think you told me, in fact, the receipt that you've given me here indicates that the paver portion that we're talking about was constructed in January of 2020?
Yes, sir.
Okay. And the last permit you gotten prior to that, I think you said was in 2017?
Yes, sir. That was when the right-of-way permit started, where I put in the site plan, showed the pavers, and showed everything that was going to be built on there.
So your contention is that that permit authorized you to construct the portion of the pavers that are...
Yes, sir. I came down to the city to say, this is what I'm doing. Please tell me what I need to do to be compliant.
Okay, that wasn't my question. My question was what the permit authorized. And
Okay.
Ms. Beavers, do we have a copy of that permit?
We don't have a copy of that permit. We do have a survey that is in our department that will show that 10 feet that he exceeded. But as far as him going to Public Works, that was his going to Public Works to get that permission to cover that right-of-way in only for the city right-of-way.
And that is the permit, sir, that you have. That's the full permit of Public Works. That's what I was told I was needed. And the coverage, there's already a variance from the previous owners before I bought it. There's a variance for 49% already on city records. And I haven't exceeded that with coverage. So the coverage technically is a moot point because I haven't exceeded 49%. I'm at 47.4%. And that was all submitted in the variance that I'm being told is not going to be approved until I rip up papers.
So based on what the permit specialists have reviewed.
Okay, speak up.
Okay, so based on what the permit specialists have reviewed on the survey that he has, The survey was considered not sufficient as far as showing the actual lot coverage. That's the part that he needs to have a certified copy of that survey submitted to our office that shows the actual lot coverage. So from the information that is being given to me by our permit specialist, what he has is not sufficient, and it's showing that he is over that lot coverage.
And that's based on the survey that he submitted for the variance that's pending right
Correct.
now.
And I've not received any clarification as to what more needs to be done for the survey. I did 2-scale. It's all, I exact the measurements. All the coverage is listed out on there, my exact measurements for doing the math of the coverage, all of that's on there. So nobody has told me otherwise with that survey.
I guess a question I have is, if you were not over the lot coverage percentage, why did you apply for the variance?
Because they issued me, rather than picking up the phone and saying, hey, let's figure this out, I was issued a violation. And so I came down to discuss the violation, and at that time I was told that everything had to be ripped up and that I had to do a building permit. So then I started doing a building permit. And they said, no, you don't need to do a building permit, you have to do a variance permit first. So then we started doing a variance permit. And then they said, no, this survey is not right, you have to have a survey to scale. So then I went out and contacted the original surveyor, got the survey to scale, I got everything. I came back even yesterday morning, I was back here submitting that again. And they said, no, you have to have the coverage written out on the survey. So then I drove back home and I redid and added all the coverage with all the measurements that anybody with an engineering ruler could have done themselves to review it. And I wrote it all out on there and did all the math. And it's all in the survey. Every single time I've come here, I've been told to do something else, do something else, do something else. And so that led up until yesterday morning when they said, okay, we'll submit this.
And so the survey that's being submitted is an unsigned, unsealed survey. So that was one of the other recommendations that the permit specialist had given Mr. Boyles, that the survey that he's submitting needs to be signed and sealed.
That was never explained to me before. They just said an official survey to scale, and if you go take an engineering ruler to it, it's perfectly to scale.
Ms. Beavers, let me ask you this question. Is the requirement that the pavers be removed pending approval related to the building permit requirement or the variance requirement or both?
Both, because the building permit was required, so the work was done without a building permit that was actually on his property back. As far as what he got the permit for from Public Works, we don't have anything to do with that part. But because the work was done past what he had a permit for, that's part of the building permit. As far as the variance, it would have to be in compliance for him to even apply for that building permit. And that's by removing the pavers that were put down.
So I guess we've got a dispute here about whether the permit, and we don't actually have the permit again. And I guess I'm a little confused still because the construction occurred before this modified permit was issued. The pavers, is that right?
The modified permit for the fence? Yes, sir. Yes, the pavers were put down in, I think around January to March of 2020.
So when was the permit issued that you believe authorized the pavers?
Back in 2017, I discussed with everybody, I said, hey, I'm gonna put gravel down here right now and then it's gonna be pavers. And that's where somebody said, go ahead and cross out the gravel, which you can see on the drawing, and put pavers down. I said, is there going to be any problem with putting pavers down here? And nobody brought up anything at that time. So I was trying to do my effort in being a responsible citizen to make sure I had everything done right. And I would have submitted all of this back in 2017. That's why I started in 2017, to get all the permits, get everything done right before I had the money to put down the pavers. So that's my entire frustration as I started this process, and the intent of trying to do everything correct. And all it's been is misinformation, 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 here's a violation. That's been my experience so far.
I think the misinformation that he's stating is he didn't understand that he got the permission for the right-of-way, but he still needed to get the permission and permit for the 10 feet that's on private property, which would be his private property, not on the city right-of-way. So it was a two-part process that was not completed. Only the first part, which was the permit he obtained from Public Works. So the second process of him getting the remainder that included his private property, that's the part that just was not done.
And I would have happily done that if I had been that explained to me. I mean, I came down here with all good intentions, and that was never told to me until after I had a violation.
I mean, typically, what's the process in terms of the interaction with the applicant?
The
Like this
permit,
gentleman, in terms of if they show a drawing and say, this is what I want to do, you know.
they would apply for the permit, and all the documentation that would have been required for that permit would have been given to them at that time as far as what they needed to submit to obtain that permit, which would have included the sign and seal survey. And then the permit specialist would have reviewed it, the building official, to make sure that the lot coverage had not been exceeded.
And I can have, that sounds like a great process, but it's not what I've seen, and it's not what my neighbor has seen, who just went through this process again, where he was told the exact same story I was about the right-of-way permit, and you're gonna hear from him in just a little bit. So he had the same experience as I did. So at first I thought maybe I misunderstood, maybe I was a black sheep, but he went through the exact same experience and was told the exact same thing, and was not notified of all of the other permits until after the fact.
When you say told the exact same thing, what exactly is that?
Go to Public Works, get a right-of-way permit, and you're good.
And that's the thing, it was for the right-of-way. The right-of-way permit is only for the right-of-way.
Tell you what, I think I'd like to hear the other case before we do anything further in this one.
Okay, would you like me to step down?
Yes,
Okay.
and we're going to hold this one for a second, we'll come back to it.
Yes, sir.
Okay, our next case is going to be case number 21312, James B. Stallings et al. And Brandon A. Stallings. This is at 116 North 10th Street, Jacksonville Beach.
Yeah, I'd just like to make a correction.
Well, wait a minute, let me hear from Ms. Beavers first.
So, for case 21312, it is about, it's pretty much the same thing. It's not obtaining a building permit as required for the pavers that were put down at the property at 116 North 10th Street. Mr. Stallings.
Are these folks next door to each other?
Yes.
Okay.
So Mr. Stallings as well exceeded the lot coverage As you can see in the picture on the left, the same thing, the 10 feet after the house, all the way up into where the air conditioner pad is, you'll see that that all has been paved. Where it should have stopped, pretty much where you see the shadow from the garage, that's pretty much where the 10 feet where the property line actually starts for 116.
So in Mr. Stallings' case, he has a right-of-way permit
Yes.
that would allow him to build how far from the street now?
Up until pretty much where you see the shadow is,
Okay.
that's where their property line, his property line starts. It's about approximately 10 feet from the house forward is where his property line actually starts. So
Okay.
anything past that, all the way to where you see the air conditioner unit at, all of that was paved would have to be removed, because that was done on permit.
All right, so you got a right-of-way permit, who would have issued,
Public Works would have issued that revocable encroachment.
so again, I want to make sure I'm getting my terms correct here.
Mhm.
There's a right-of-way permit for the area that's within the city's right-of-way.
Correct.
And then an encroachment permit is for,
Given permission to pave that right of way.
two separate permits?
No, that's the same thing.
Okay,
The
okay, that's
revocable,
what
I'm sorry.
confusing me. You
Yeah.
call it a right-of-way permit, and you then call it an
It's
encroachment
the
permit.
revocable encroachment.
Okay, so for the portion then, again, you know, in the shade, if you will, who issues the permit to authorize that?
Planning and Development, the building department would have issued.
Okay, that's the building permit,
Yes.
okay, I got it. And does this also require variance, or is his lot coverage sufficient?
He has exceeded the lot coverage. He can apply, just like our previous case, he can apply for the variance and see if he's approved for it, but he's already exceeded the lot coverage.
But the variance would allow him to.
If it's approved.
If it were approved.
If it's
Okay.
approved.
Okay, all right, I'll hear from you now, Mr. Stallings. And would you state your name for the record and your address?
Yes, my name is Brandon Stallings, and I'd like to make a correction. It's actually 116 10th Avenue North,
Okay.
Jacksonville Beach, Florida. Yes, so basically, just like the previous case, my papers were installed in a different time period, but
Let me clarify, when were they installed?
they were installed in April this year, 2021. And, you know, how I started was I saw the exact same thing. You see sort of in the drawing that it's very similar, the two properties, as far as like the papers in the front. I started by, you know, approaching my neighbor, asking sort of what did you go through back in 2017 to, you know, get compliant. So I actually started by going to City Hall. I spoke to, and that was back in March. That was actually back, you know, probably February, March. I don't remember the exact time, but it was before I did anything. It was before I actually started this project. So I went to this the zoning side of the office right here. Ms. Beavers actually works there. I spoke to one of her coworkers. I believe it was Deanna Roders. I might be mispronouncing that last name. But I actually went straight at them and said, I'd like to apply for a permit, whatever you need. I didn't know at the time exactly what was needed. I didn't know the terminology of variance, of building permit. But I said, I'll do whatever you need to get compliant. Whatever you need, I'll fill out the paperwork. And basically, we had a little exchange. She asked me if I was a first-time homeowner. I said, yes. And she said, well, it's actually Public Works that you need to go to, and that's who will take care of you. I was not told at all that I would need to come back for a variance or building permit or whatever permit. Okay, so I go to Public Works, I talk to them. They actually didn't know what I was applying for at first because I was talking about, I guess, what, they sent me back to City Hall again. And then I got sent again back to Public Works where they finally figured out, okay, you're applying for a right-of-way permit. So I was told twice that it was just a right-of-way permit, and then you're good.
Okay, you went to Public Works and they said you're in the right place, all you need is a right-of-way permit, is that what you're saying?
Right. I was just never told when I stood right there in front of their office, I guess which is planning and development, and Ms. Weavers, you can correct if that's not what it is, that I was never told I needed to apply for anything else. I needed to start with this permit right here, which was a right-of-way permit. I do have a copy, if you would like.
Okay, yes.
And then I also have sort of a letter here explaining basically everything that we did. So it's some of the details are extraneous, but it's just basically about talking to all of the utilities.
I need you to step back there and talk in the microphone, so everything you say is taken down.
So basically, in addition, I was trying to get ahead of it. I was trying to do everything right. This was before, like, the yard was, before anything occurred. Before this, there was just grass, okay? And essentially, this property that's, I guess, in question is part of our private property. I think that's one of the things that wasn't mentioned before was, I think this, and you can correct me, but this ordinance has to do with it being a hardship, okay? Essentially, our private property, we can allow, we have the right to essentially put up a sign that says no trespassing. I mean, it's not going to cause a hardship to anyone, in my opinion, but basically, in gathering all the necessary material to get this done, I went to both of these offices, twice, Public Works and the zoning department over here. I was told right-of-way permit. I got that right-of-way permit. It's fresh. I, in addition, had the city electrical come out. I had different departments come out. It's mainly electrical because that's the only utility that is public that's underneath the ground on my spot, and then sewage. But I got a recommendation, and basically when we put this in, there's access points to the sewage, there's access to the electrical. It doesn't cause a hardship for the city because the city official, we followed his exact instructions as far as installing. So there's nothing that prevents them from getting to anything that's part of the city in terms of just sewage and electrical in this case. The rest of it is utilities that have to do with my own home, such as cable, water. So again, I thought I had done everything right. And I believe it was in May when Ms. Beavers approached us and put these on our doors. And basically, we had no idea that this was required, and it was never made clear to me. It was never made clear to my neighbor who told you that he did this back in 2017, and it went over the property line and everything. And, once that occurred, I, felt like, since it had been there for so long, that if I do what he does, then we're good. But, and I'm not sure exactly how this came about either, except for, I guess she said someone saw this, and that's why we're here.
Well, the building official saw it, and I
Correct.
guess recognized that, checked and recognized that it was not permitted, and that, the lot coverage provision is, when you say, there's no hardship associated with it, they exist because of the amount of stormwater that impervious surface generates, which can cause flooding. It's not controlled, and that's why the ordinance exists, that you can only have a certain amount on your lot, because otherwise, if everybody completely paved their lots, you'd be flooded, and you wouldn't be able to drive in the street when it rains.
No, I'm really glad you bring that up, because when we, when this was installed, actually, we checked on that as well.
Checked on what?
As far as like the flooding mitigation. and we installed a drain, okay, that has endpoints on both ends in the middle, so these are permeable, and then the drain actually will mitigate flood water. Yes, thank you. So, you can't see it, but you see a couple of drain, a couple of those end caps. There's an end cap actually on the far end. In that middle section, it's like a utility area that's used to sort of manage everything as far as what's underneath it. So, I mean, you see electrical there, you see AT&T there. We helped them all out, we installed piping. We also, as far as that drain, the reason why that's important is because it will help with flood mitigation, and that was the recommendation for the city. Okay, I mean,
Ms. Beavers, do you want to see this permit or the letter that?
I've already reviewed them, when they submitted their variance application.
Have you submitted his,
I have. I've submitted a variance application to my knowledge, the survey, and here it is right here. I can present this to you. It's has not been, nothing to my knowledge has been rejected. So if there's anything that's out of compliance with the variance application, it's going to be new news to me.
The survey is missing the seal.
Okay, so it has to be sealed.
The seal and signature from the surveyor.
That's okay. So basically, what you have in your hand is a copy of the improvements of the property that we did, the percentage of the lot coverage that it makes up, and then you have the original survey. And we had no idea that it also had to be sealed. As a matter of fact, when I turned in the variance application, the person, Leanne, extensively looking over each page of it, said it was good. I think she just had me sign it, and that was it. There was no seal. So I wasn't even told when I turned in the application, and they looked over it, because I made sure, because like my neighbor, I was rejected several times. So when I finally came back the final time, I said, let's look at every single page and make sure this is good. And they said, okay, yes, so we'll follow up with you. In addition, I think I went through the same runaround where it seems like reasons to reject the application keep being invented.
are you talking about for the application that you've got pending now and the variance?
Yes, so I was rejected once. I needed to also, at the time, write a check, and even though this is the official survey that I was given when I bought this house, I needed a survey to scale. I went back, I got it. We did what you see there, a drawing of the improvement, and I was told that, just like I was told that I need to apply for a permit, I need to apply for a right-of-way permit, and then everything's okay. I just turned this survey in last week, and everything was okay. After going over this and all, after going over every single page. So, like my neighbor, there keeps being a new reason to reject this application, in my opinion. I would appreciate it being made clear, because I have no intention of, being out of compliance with anything. If I had known about this, I would have done all of this before I got this installed.
See one?
Yeah.
Testimony, okay. And you'll hear me, did you stand up and swear in?
No, I was actually asking.
Okay. If you could raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you state your name and position for the record?
Sure. I'm Christian Popoli. I'm the senior planner for planning and development. Just to address a couple of the questions on the procedures.
Sure.
The people at the counter that actually accept the applications.
Okay, slow down a little bit.
Sorry. The folks at the counter that accept the applications do a very initial review, trying to make sure all the piece parts are there. Per Chapter 34, we have a period of time to actually review them for sufficiency, and I'm the one who does that. So anything that was turned in yesterday, we haven't reviewed yet. That'll probably happen later this week, maybe early next week. So if there's anything missing from their applications, that actually hasn't been officially determined yet by the department. So they may have caught some things initially that, there wasn't a survey or didn't have certain parts, but there may be other things still at this point that are.
Right.
And just on the question of the right-of-way permit, technically, Public Works doesn't have jurisdiction over the private property, so anything that they approve could only have been in the right-of-way, whereas planning and development and building would have purview over anything in the private property. So there's no way the right-of-way permit could have authorized anything on their part.
Right, but you can understand how someone came and applied for the permit and, if they showed a drawing that had the entire thing there, and everybody said, hey, you need to get another permit for the other part of it.
Right. I understand. I unfortunately wasn't here when these were applied for initially, or at least the previous one.
Right.
I don't know how Public Works reviews those, but certainly on the counter side, the building permit and the variance are required. And in this case, the variance by definition can't be applied for if it's a self-inflicted hardship, which is where the reversal comes from.
I'd like to, may I?
Sure, go ahead.
Could you explain further how the property owner themselves can create a self-inflicted hardship? I think that,
So in essence, if you've done something that has created a hardship, in this case exceeding your lot coverage, the variance is there to address things like deficiencies in your lot. So if you had a substandard lot for some reason and your house was non-conforming and that deprived you of the ability to do a swimming pool or something like that, you didn't create it, but you were asking for relief from the code. In this case, you, by violating the code, created the lot coverage issue, and so therefore it is self-inflicted.
is it substandard in this case?
I don't know, I haven't reviewed the application. But adding additional lot coverage would be considered self-inflicted.
But you know that the documents, as far as the survey is unsealed. So who told you, if you don't mind this, who told you that
The permit specialist.
Okay.
The permit specialist had stated that the survey that were initially submitted for the variance application were not sufficient.
And that's the
You would speak with Shannon
Okay,
and
can
then.
everybody speak up a little bit? I'm going to make sure.
Okay.
Well, I just wanted to make sure because the person who was supposed to turn this application into, who said it was fine, okay, I guess it was someone different who reviewed it and said that the surveys needed to be sealed.
It's actually stated on the survey as well, at the bottom of the survey.
I don't understand what you mean. The survey needs to be sealed, but it's stated on the bottom of the survey.
It's stated on the bottom of the survey as far as it being certified.
The survey that I turned in was certified. It's my original survey from the original company that surveyed it.
So in regards to the variance process, which is going to be separate from what we're here today, the main thing is bringing it into compliance so that the variance application can then be reviewed. But none of that will occur until the property has been brought into compliance by removing the pavers that were actually installed on the private property.
Right. So, Mr. Magistrate, what she's essentially saying is, after having just installed this on the property, to simply spend thousands of dollars on removing it just so I can apply and then put it right back.
If it's approved.
Okay.
Your Honor, can I bring the building official up who actually?
Yes, please.
Your Honor, good morning.
State your name for the
My
record.
name is David Martin.
Okay.
And so I am the one that noticed this happening before it happened. The neighbor who was up previously had already had theirs done when I saw this. I saw the one on the left here, this gentleman's, before it was happening, before any papers were down, is when I went up and put a notice on the door that they had to apply for a permit.
Right.
That's incorrect.
Hold on a second. Is that for Mr. Stallings' property?
Yes, yes.
Okay.
Yeah, the neighbors was already down and done before I'd seen it. But Mr. Stallings' property was under construction. It was sand and paver base was down. No pavers were down when I viewed it, and I put a notice on the door.
Again, we're talking about Mr.
Yeah.
Stallings.
Mr. Stalling,
That
yeah.
is
You're
incorrect.
sure?
Yeah, I'm sorry.
You'll get a chance to talk in a second, just hold on.
Mr. Stallings.
I want to hear one at a time.
Sorry.
Go ahead.
Mr. Stallings' pavers they were starting to do them, but they were not down at the time. I went up, posted a notice on the door for them to make contact with us. No one was home at the time. This should have been, this was talked about before the pavers were put down. So the thought of not knowing that you couldn't do this work without a permit is incorrect, because he was notified before the pavers were installed. Unlike the neighbor maybe got some information from Public Works, that was before. This gentleman, Mr. Starling, was notified before those pavers were installed. And Public Works, if you apply for a revocable encroachment permit with Public Works, they will tell you that you can put the pavers down in the public right-of-way up to 10 feet from the house. That is completely separate from the lot coverage. Mr. Starling was already at 50%, he was approved for 50% lot coverage before his paver installed. He would have to then come in, apply for another variance, get approved for the variance, and then apply for the building permit after that. The pavers that are installed on the homeowner's lot that violate the lot coverage requirement, one drain is not sufficient. These are impervious, that's an impervious surface. So that one drain is not sufficient for drainage to meet that lot coverage requirement.
All right, so again, let me make sure I understand. The right-of-way permit gives the right to encroach in the right-of-way.
Yes, sir.
That's not a building permit, though.
No, sir.
So you would need a building permit for that portion of it.
Yes.
You would need a building permit for the rest of it as well, the others that's not in the right-of-way.
Yes, sir.
And then you need the variance for whatever portion of it is going to send you over that 50% lot coverage.
Any impervious surface, yes, sir.
Yeah.
Whether that be a roof,
Right,
pavers,
understand.
whatever that may be.
Yeah. Okay, Mr. Stallings, go ahead.
Okay, thank you. I'd like to present some documentation. I'd like to first start with the types of pavers that were installed on the lots. So there are a couple of things that I'd like to clear up. One is these are permeable pavers. This is permeable. We got these installed to code. Gravel underneath, layer of gravel. The drain in the middle is just one drain. There's actually three drains. There's the ones coming from our houses also. You see one on the right from my house. You see two. You'll see in that front little area in the middle between our pavers on the left photo that there's actually two drain pop-ups. Okay? So, we do have drainage installed. But the middle drain is just for that middle area. It's kind of like it's like a dedicated drain for this improvement. You'll see in my letter actually that I wrote that we went to extensive lengths to make sure everything was right before installing all that you see here. In addition, it is, I cannot say how incorrect that it is that I received any sort of notice of needing to apply for a building permit or a variance before this was installed. There was not a notice put on my door. The only notice that was ever put on my door was on April the 23rd, after this was installed, saying that I'm in violation and that I have a hearing. If anything, okay, I mean, they might have, I don't know, I don't know where they got that from. I don't know where they got that from.
You're saying that there was no door hanger on your door saying contact us about your pavers?
Nothing. Nothing.
Anybody else live in the house besides you?
No. This also, this might be extraneous, but this is the original, the only variance that's like been approved for this property was when the home builder built this home. So I'm gonna have proof of that too if you need, but I think it's not necessary.
Sure, can I add something too?
Not yet.
Okay.
No. Not unless you testified about his case.
I am, yes, sir, I am. If Brandon, if you mind, don't mind.
All right.
I work
And
from
to
home.
be clear for the record, this is Mr. Boyles, Jesse Michael Boyles.
Yes, sir.
And the testimony you're offering is in case number 21-312 at this time.
Yes, sir. I work from, you can see Brandon's third floor window. My office is in mine overlooking this property. And when Brandon was doing all of his pavers and everything, I was paying close attention because I'm a mining and mineral engineer and I know soil, I know how to do all of that. And I was actually the one that planned out the whole French drain. It's an entire French drain running down the middle of that is over 10 inches deep and about 10 inches wide. So all of that gravel is a full French drain with a pipe at the bottom properly built. I saw the city come out. I don't remember if it was him or not. I saw the city truck come up when Brandon's was half done and take pictures, and I didn't witness any permit or anything put on any doors. I sat on the third floor balcony and watched the whole thing because I work out of that office every day. And I stand there and look out the window. And I saw someone come in to look at the pavers, and I watched them take a picture, and I debated if I was going to go downstairs and talk to them or deal with it later, and all I saw was them take a picture and drive off. So that's all I wanted to add. Thank you.
I happened to be coming home from work that day on April the 23rd to run into Miss Beavers, who was taking the photos, and this was the first thing. She actually taped it on my door, and seconds later, I pull up and I see it. So this was the first notice I ever received in regards to this. There was zero foreknowledge before that.
State your name again.
Christian Popoli, senior planner.
How do you spell your last name?
Popoli.
Okay.
I just want to address two quick things. One, pavers are given a degree of perviousness, and that's one of the things we review. So this particular type of paver typically has a pervious rating of about 9%, so it would still count towards lot coverage.
So it's 91% impervious.
Something to that effect. It varies depending on the manufacturer. Typically, it's because of the spacing between each one that allows water to drain. Number two, the entire purpose of the building permit is to address drainage design and engineering. So without having gotten the permit, there's no way to determine whether the drainage is sufficient or not. Hence the permit process for the review. Just to address this question of drainage, we don't know that answer. So whether it's designed correctly or not would require that permit.
If I may ask a question, who decides if the drains are sufficient? Like, what's the title of it? Could it be, like, what the city department does that?
It would be through planning and development through the permit process.
Okay. Well, all right. That helps, all the city officials that came out to review our property before getting it installed didn't say anything, so. And they actually gave me raving reviews over the drain that Mike installed, so.
Okay, you need to keep your voice up because
Well, what I was saying was, again, we had electrical come out. We had, and basically, I know that that's probably not the same department, but again, with everyone who came out to look at our property from the city and from other various utilities, we were told that it was correct. Okay, and that actually the drain that we installed, given that we have our other drains coming from our home, it's extra. If anything, only because that, we know our property really well, and we've lived there for long enough, and we've designed it in such a way where if there's something that we need to get to, we'll get to it and we'll fix it. Not anticipating that there's anything that needs to be fixed.
okay, you have anything else, Mr. Stones?
Not that may be pertinent to the case. I have my violation.
You have your what?
I have this notice of hearing,
Okay.
you know, but again, if I may just, I guess in closing, just state that what we're essentially being asked to do is rip out or take a jackhammer to what we've installed so that we can submit an application to appease this department who didn't tell me on 3 separate occasions that I was gonna be in violation of anything, or that I need to apply for anything. No notice on my door, no nothing. They had a chance to tell me. I got that right-of-way permit, okay? And we're being asked to remove this installation in order to submit an application to get approved and to then reinstall it, which would cost us thousands of dollars. So if there's any hardship, that, in my opinion, is the hardship, because this isn't really bothering anyone otherwise.
Speakers?
Okay. As far as Mr. Stallings stating that he was not previously notified, the case was initially started on March 13th. A violation notice was mailed out through U.S. mail. After that violation notice, he was given time to come in and apply for the permit at that time. A second violation notice was also sent out. It was also ignored. So after the 2 violation notices are sent out, that's when the case is brought before the special magistrate. As the building official also stated that when he initially saw the pavers being installed, a stop work order was placed on the door. That is something Mr. Boyles would not have been able to see, because the way the door, if you see, the front door is actually inside, where it's away from a side view of someone's putting a notice on the door. Again, that notice from the building official was apparently ignored, and the work continued to be done. As you can see, the work was completed after the building official had already notified him that he needed to stop and come into our office.
May I say something?
Hold on a second. Go ahead. Go ahead.
Okay, yeah, so, in regards to Mr. Stallings, and his property, he would have been in violation of not obtaining a building permit after he had been notified by the building official as well as from our office.
Okay, well, let me ask you this. If he had come in response to the you say the first notice you gave him was in March?
Correct. Well, the first notice would have been when the building official
Understand.
originally.
Just, in the notice that was provided to him by you in March, was that by mail or was that?
That was by mail.
Okay. And if Mr. Stallings had come in at that point, would things have been any different in terms of his ability to apply for the permit and the variance without first removing what was there?
That would have been, he would have been able to apply for the permit. I can't say if the building official would have opposed any fines at that time, being that the work had already been done. But because the building official had initially told him to stop the work, then I'm not sure if that building permit would have been issued. David, that's probably something that you could
I
probably
wanna-
clarify.
Yeah, I'd like to ask
Okay.
Mr. Martin again if I can. You know, this is kind of difficult, again, for the reasons that both Mr. Stallings and Mr. Boyles have said. You know, you're telling me to apply for a permit, tear this up, and then if I'm granted the permit, I can put it back. And I certainly understand the concept of, you know, there's an existing non-compliance, you know, you have to correct the non-compliance first before you get the permit. But I'm trying to understand, I got 2 questions. First, do you recall when you were out there when you put the notice on this door?
Saturday, March 13th. And then his notice was sent out by Ms. Beavers on March 16th.
Okay.
That's when his notice was sent out through the mail on March 16th. I work on weekends, and I typically come back on Monday, give Ms. Beavers a report of the things over the weekend. She sends those letters out. That was sent out on March 16th. As far as the working without a permit goes, we did not impose a fine. We just wanted Mr. Starling to come into compliance and apply for the variance and/or permit. I do remember, I'm in this office every day, and I do remember Mr. Starling coming in several times. As he stated, he came in several times, but each time, each person that he talked to, he got the same exact story of what he needed to do. It seemed like he wasn't clear, maybe in his own understanding, but each time he talked to the chief building official, George Knight, he talked to Deanna Yoders, who is our permit tech. He talked to Chandra Medford, who is our permit tech. Everybody told him the same thing. I was witness to this multiple times. As far as the work going on afterwards, when we post that stop work order, if there's work that continues on after that, it then could become a legal case because it's illegal to do that. So we were trying to work with him. We were trying to get him come in compliance because the work hadn't been completed, unlike the neighbor's house. So
Hold on. I'm gonna give you a chance to talk. Just hold your horses. I guess what I'm trying to understand is, if his situation changed in terms of his, and this would be the same, Mr. Boyle's. Well, actually, it isn't the same. It is slightly different. But in this case, with Mr. Starling's, if in fact he had stopped at that point and had come in and applied, would he have been required to remove anything pending that application and either being approved or denied?
no, sir. No, sir. That's the short answer. The longer answer is when I viewed it happening.
Well, hold on a second.
Go ahead.
Okay, the answer was no, he would not have been allowed, he still would have had to remove until he got the variance and or the...
No, sir, that's incorrect. They weren't even installed. So he
Okay.
would have nothing to remove. And that's why we tried to catch it early.
Understood.
When I went there, nothing was installed on his lot. They were starting in the easement and in the revocable encroachment, which they were allowed to do. But on the lot coverage issue, this lot coverage was granted a variance in 2014 for 50%, which is over 15% over the 35% standard lot coverage. So that was already granted that variance. In order to put more pavers on there, you obviously had to come back and apply for a new variance, but there was nothing to remove at the time. Had he had stopped, there was no hardship incurred by him had he had stopped. Now that the pavers have been installed, he continued on with work without a permit.
Right.
That's
The hardship,
self-inflicted.
as you suggested, is not, you can't create your own hardship.
Correct.
So exactly what would he need to remove in order to be in compliance such that he could apply for the variance and the building permit and, see
The
what
10
happens?
feet from the structure and also the side that you see that's along where the air conditioner unit is. Those pavers on the side and 10 feet from the actual structure where his property line actually would start.
And if
So-
I may expound on that a little
Yeah,
bit,
go
we're
ahead.
not sure if anything has continued on past that fence line. We haven't seen anything past there, so anything that has been added to that property, paper-wise, would need to be removed and applied for. So if there's anything behind that fence that we didn't see, we're not sure.
It looks
Well,
like-
what we can see is there from where the shadow goes up to that fence would need to be removed, but we don't know what's behind it.
Because looking at the gate, you can tell
It
that
looks like it goes
like it's
behind the
still
fence.
behind the fence, that more space behind the fence. If you're looking at this left.
It possibly looks like it's continued on through the fence.
Okay.
You have in the drawing.
Hold on one second. Anything else? Okay. Mr. Stallings, now is your turn. I want to hear anything else that you've got to say right now.
Thank you, Mr. Welch. So first, I'd like to say that the drawing makes it clear what I did, okay?
And speak up a little bit now again.
Sorry. So the drawing that you have, the first drawing that I gave you has the improvement, so that's exactly what it is, okay?
So you're saying nothing goes back beyond the fence?
No, I'm saying it's exactly what you see there on the drawing, okay? And in addition, there was a lot said there. Again, I'm going to stand by the fact that I received no such notice. Okay, I checked my mail. I received no such notice of violation or of the need to apply for any sort of permit. I was told in person by this office repeatedly, and same with my neighbor, that he just needed the right-of-way permit. I was never told anything about a building permit. As a matter of fact, just, going back to his story of, they said that you need a building permit first, and then he goes back and they say, wait, you need to apply for a variance first, and then a building permit. So, back and forth, there was nothing ever taped to my door that had to do with the city of Jacksonville Beach talking about this property. There, I get stuff taped to my door like pest control, okay, or cleaning services, not this sort of documentation. This is the first document related to this that was taped to my door. And what they were talking about as far as me coming into the office several times was after the work was completed, and I'm trying to apply for my variance, and they keep finding reasons to reject it. That is why, that is, I'm pretty sure what they saw in terms of me coming back and forth, because I only came here twice to make sure that there's nothing else I needed to apply for, except the right of way. And then, and I'd like to also state for the record that, and, I can possibly speak for my neighbor, that we were trying to do everything we could to be legally compliant. It is not any intention of mine to not be in compliance with any ordinances or code or anything. We worked extensively on this for weeks. We had city officials. We made sure every utility, every single thing was in place to the T, and we were just never told that this part had to be done. Okay, we would have, we would have fully complied, filled out the paperwork, okay, and I believe there's a non-refundable fee attached to the variance. That's fine. We would have done that. I would have done everything. We just were never made aware. Not until, I guess, for them it was too late.
Okay, anything else? This is your last shot.
I believe I've stated everything fully. Again, this is our private property that they're asking us to remove in order to go apply for a permit, and then if it gets approved and reinstall. There are hundreds of properties that we've seen that have pavers or some sort of gravel situation. There's a neighbor right across the street from us who has the same situation, and it goes past their right of way. Okay? We were never told anything. And now, again, it is our goal, or it was our goal before this, to be totally legally compliant. I thought I did everything correctly. No knowledge of being out of compliance with planning and development. And we were told by them that it was okay. So I rest my case.
Ms. Beavers, one last question to you. Mr. Martin said that he gave his notice on March 13th, I believe, and that the first letter that you sent to him
Was on 4/16.
March 16th. How was that letter? Was that letter sent
The
certified?
No, the only thing that would have been sent certified, which would have been the notice of hearing. So on the 16th, a letter was mailed, a final notice was sent again of the violation on 4/7, and then on 4/23, the certified letter and the notice that he has that was posted on the door for the hearing today was also sent.
In the case of Mr. Stallings, has a determination been made at this point whether the lot coverage exceeds the 50%?
It was exceeded back in 2014. So anything, when the variance in 2014 that was approved, he was already at 50% at that point. So he wouldn't have been approved for anything additional because he was already at 50% in 2014.
Okay, what I thought I heard Mr. Martin say is there was a prior variance that allowed the prior owner to go to 50% lot coverage.
Right.
Please stand back just a second.
Yeah, right. So what I'm saying, as far as anything additional, he probably wouldn't have been approved because he was already at that for 50%.
That really wasn't my question.
Okay.
The prior owner was approved for up to 50%. So this lot, whether it's still owned by the prior owner or Mr. Stallings or anybody in between, would have been allowed to have impervious up to 50%.
Correct.
So, my question is the determination been made that with this, with these pavers, that 50% lot coverage has been exceeded?
Correct.
All right. I'm going to give you one last chance. What did you want to show me?
Well, I just wanted to show you the approval for the variance of my lot.
Okay, speak up again.
I just wanted to show you the variance for the approval of my lot. This was actually a variance that the builder of my home applied to. This was new construction, so yes, my property had already been approved for this lot coverage before I owned it. Okay, so would this be helpful?
No, I mean, essentially, all that says that you can go up to 50% lot coverage. Is that what that variance says?
That's the way I interpret it. Yeah. Would you like to have a look for yourself?
No, I mean, that's consistent with what Ms. Beavers has just said. And the issue is going beyond 50% lot coverage with the work that you did here.
Correct. Yes, which is the percent that we went over 50 is actually on the drawing of the improvement. We're at about 60.49, I believe, in terms of the total.
Anything else?
Nothing more than what I've already stated. Again, we didn't mean to do anything wrong, but we were just never made aware. So we just, this is why we're in this situation. This is why I'm here. And essentially, if what we're being asked, I think, as far as like looking for hardships or anything, I mean, it's essentially ripping out papers just to just to submit an application, which has been submitted, and I believe we're going to go before a board to talk about it, and to then reinstall that same stuff, which would in itself be a hardship on us as neighbors because it would cost us thousands of dollars that could otherwise be avoided. And it's our own private property, so as far as like it being a hardship to others, the city and the like, again, it was the city's recommendation as far as everything that we installed and having access to electrical, sewage. They have access to all of that. There's been no complaints by any other city departments about what we did here, drain. You'll see in my letter how extensively we prepared the ground for this property. And we honestly believe that we did everything correct and applied for all of the necessary permits in order to install this. And the only thing that will change, and really, like if I had, say I had applied for this before, say my neighbor and I had, and by the way, it took them 3.5 years, I believe, to catch my other neighbor doing this. Not that we thought we were caught doing anything, but once they finally saw this, I mean, we would have, actually done this correctly. I think the only thing that would have been different was we would have applied. We would have either gotten approved or we wouldn't have. From what I understand is you apply for a variance. If that doesn't get approved, you gotta apply for a building permit. Say we get approved for one of those, in one of those steps in the process, then from what I've heard today, we would have been able to do what we've done without being in violation of it. So I think that's the difference that we're looking at, and with that, I conclude.
May I have these items put in the record?
Well, I think I need to hold on to a copy of the permit. Would it be possible to make a copy?
Okay. I'm going to hand these to her.
And same with some of the other documents. I need to take a look at what I gave you, just make sure I have a copy of everything.
Okay. Well, when we're concluded here, I'll have these right here, and we'll let the clerk know which ones you need. Keep the originals, and we'll put a copy in the record.
Keep them there for now?
For now, yeah.
Okay, all right.
Well, I'll tell you what. Yeah.
No,
Right. Let's do that.
And I can copy everything and give it all back to you, so as long as we have copies of everything, that's fine.
Yeah, this is actually okay. I just need a copy of the permit. That's all I need.
Copy of the permit, which
Yeah,
is.
they agree.
Good, yes, sir, I will do that. So when we're done, we'll just go to the city clerk's office, and then I'll make a copy for you.
Thanks very much.
Yeah, absolutely.
Ms. Wait, don't, come back in a second. Mr. Strong, you're going to finish right here now. What is your recommendation, Ms.?
My recommendation is for him to remove the pavers, like he stated. If he would have went through the correct process, more than likely the building permit would not have been issued to Mr. Stallings because he was already at the lot coverage that had been approved back in 2014 up to 50%, so he probably would not have been approved for the additional pavers. Again, my recommendation that also comes from the planning director as well is that the additional pavers be removed.
All right. And you need to specifically tell me what, when you say remove pavers, what specific portion?
The 10% that is, not 10%, the 10 feet that is actually from where the property line starts, all the way through the side, where those pavers are on the side of the property.
All right.
And anything beyond that, because
No,
like he just stated,
one more.
he's at 60%.
All right. Back up a second.
Mhm.
10 feet from where?
10 feet from where the actual structure is, so 10 feet forward. So the only thing he's approved for is the right of way.
10 feet from the edge of the building?
Yes, forward. And that would also include those on the side.
So it would be all pavers that have been installed
On his private property.
to the point of 10 feet beyond the structure.
Correct.
What time period are you recommending?
I would give him 30 days.
All right, here's what I'm going to find. I want to explain this. That it does require a building permit. It does require variance, and it doesn't have either one of those. So you are in violation of those provisions. And that can only be cured by either removing the pavers in the area that there is no permit or variance is required, or that they be approved. Now, what I'm being told is they won't approve it until the removal occurs. So what I'm going to order is that within 60 days, you either remove the permit, remove the the pavers in the area that we're talking about, or obtain the permits. Now, I don't have any control over whether and under what circumstances the city issues those permits. The only thing that I can do is find whether or not a violation has occurred, and what will take care of that violation. So, it's kind of going to be in the city's court at this point, as to how they handle, the application. But that's, again, that's what I have the authority to do. So I'm going to be entering an order to that effect, and so you'll have 60 days. I'm giving 60 days because I don't know how quickly, if you do have to remove them, how quickly you're going to have to get a contractor out there to do that.
Just for clarification, we already submitted our variance applications. We basically have sort of, I guess, an approval meeting. They say that it won't be until July the 6th, which is kind of like 2 weeks before the 60 days is up. If we do need a building permit, which again, we were not told by this department, that if the variance gets approved, then you don't need a building permit. Okay, so that is what's on the schedule right now, is whether we get approved or not. But we're not going to know if we get approved until very close to the end of that 60 days.
Christian Spicoli, city planner. Since it hasn't been reviewed for sufficiency, it's not currently scheduled for any hearing. So the July 6th agenda has been closed by applications that have been reviewed and approved. So he doesn't actually have a hearing date as of yet, but it'll be after the 6th, for sure, if that helps.
That does. So how soon after the July 6th?
I don't have the schedule. I think 2 weeks at this point, provided it's sufficient and it's approved for sufficiency in the period before the next agenda is set. Again, I don't know that it'll be approved for sufficiency if it has a standing violation, so.
I'm gonna provide the date of August 31st.
Okay. Can we do the fourth Wednesday of that month, so then that way Al will know
Yeah, I
to
think that.
put it on the calendar?
Let me see when that is.
Yeah. So I can then schedule it for the hearing in the end of August, that last Wednesday of August.
That would be the 25th.
Okay. So in your order, can it state that it would be, needs to be in compliance by the 24th? So then that way, when we come on the 25th, I can state if it's in compliance or not.
Yeah.
Okay.
That's fair.
Okay, thank you.
Okay. She's gonna make a copy of that.
Is this, by the way,
Yes,
same
I'm waiting
for
for
my
minutes.
neighbor?
I'm sorry?
Same for my neighbor, same order for both of us?
Well, I'm gonna call him up right now. So, and I apologize. Come on up. So we're done with case number 21-312. And we're going back now to 21-313. The one thing here that is still of concern to me is this, again, the variance requirement and the exceedance of the lot coverage provision. And let me clear, and so just to make sure the record's clear, we're back on case number 21-313. Has there previously been a variance granted to exceed the 35%?
Yes, so I want to say your variance was back in 2015 or either 2017.
Same builder
It was-
built all of these, and they have the
Okay.
same variance on all of them.
Okay.
It's on record in the city,
Okay.
I just submitted it with my variance. It's
Yeah, I don't have it
50%.
in front of me.
And my current coverage is at 47%. You can see on the, actually, I'm sorry, I didn't submit the survey that the city has on the variance application.
And we don't have a survey yet, at least in connection with his application, that either certifies whether he's over the 50% or not. Is that-
And the permit specialist, they do have a copy of that survey. I can't say right off the top if that is a certified copy of the survey, but they do have a copy of the survey.
So, I mean, again, has a conclusion been reached? I thought
That
I
he's
heard from,
exceeded.
hold on a second, thought I heard from Mr. Boyles earlier, he disagrees that he's, even with this new construction, that he's over 50%.
I'm at 47.4%, sir.
Okay. So based off of what the permit specialist stated in her notes, was that with the survey that was submitted, that is unsigned and unsealed, with added improvements, new coverage would be at 47.4%. But again, she stated that it's not sufficient because it's not a signed and sealed copy of the survey.
And I can attest, I'm a monumental engineer by education. I know how to use an engineering ruler, and it's correct. I'll go get it certified if I have, if that's what I need to do, but
Here's what I'd like to do in this case.
Okay.
You know, I'd like to, because I think we're going to have calendar next month, aren't we?
Yes, but it would be too late for me to add them to next month's. Unless he agrees here on record that this would be proper notice for him to attend next month's hearing.
What I'm trying to do here is I want to try to nail that down, whether a variance is required or not.
Yeah, it would just be notification, so.
So would you be willing to agree to appear next month, a week from now, and submit, get the certification on the survey so we can,
I would love to, sir, but I've already spoken to the survey specialist that did the original survey, and he provided me a new copy. And for him to come out and sign, I've already been told that he can't get out before July 2nd. So that's why the survey that I submitted is not signed by him. He just gave me the 2-scale copies so that I could appease what they were requiring. And then he said that he could come out and he had to resurvey everything at a cost of $550 to me. And he said he couldn't get me on the schedule before July 2nd. And so that's why I can't agree to that, because the surveyor that did the original survey that they're asking signs and stamps it has told me his schedule's full till July 2nd.
Can I say something?
Yes.
Yes, our permit specialist just brought in a copy of that survey. So the 47.4% is not accurate because it did not include the walkway, and I'll show you.
okay.
This is-
All right, you need to do this.
So the blue shaded section is the part that's not included on the survey. So that 47.4% would not be accurate.
Okay. You want to see this? Sure.
Yes, I'll agree that's there. That's nothing I added. I didn't add any of that.
Okay. But it's still,
There's the walkway there. Yes, sir. Yeah.
okay, it still counts towards the 50% or plus.
I didn't know because it wasn't on there from the original survey,
Okay.
and so I didn't know what counted or what not, and that's why I assumed they probably wanted to stamped.
So, Ms.
But
Beaver,
that's-
is it your testimony that this puts it over 50% based on this area?
It could possibly put it over 50% because that was not included in the survey, and he's already at 47.
We can do the math really quick. It's, I can look at that and tell you it's 3 feet by 7 feet is that walkway. 21 square feet, it adds to that. So you can, on that survey, I already have all the calculations right there. You can add it and do the calculation really quick. But 21 square feet isn't going to move 3% across 2,800 square feet of total lot. Doing quick math in my head.
My recommendation would be to provide that certified
Okay.
survey. So if he agrees on record that he can attend.
He's saying he can't get it by
Oh, okay.
June.
That surveyor's not
maybe.
available until after July 2nd. That was 2 weeks ago when they
Yeah.
started asking me all this. So
So
I
we'll put it
tried to
on
get
August.
Do we just want to put it on the, okay, we'll put it on, then and you can notify him by then, but
Yes.
what we'll do is continue this until
August 25th.
the same August 24th date.
So is it the recommendation that I need to go pay for a completely full new survey, that me putting the correct measurements on there and verifying that all of it's correct is not adequate? Is that the recommendation? I have to pay for a whole new survey?
It has to reflect the current conditions.
You're gonna have to have that survey to get your permit.
And it needs to reflect the current conditions. Like I said, the certified showing everything, including the walkway.
So, I mean, you're gonna have to have that, and, you know, again, if it ends up showing that it's less than the 50%, then we can, you know, dispose of that part of it.
Yep, yes, sir.
Okay. All right, so this will be continued to the 24th of August.
Okay,
Okay. All right, thank you.
yes, sir.
Let me ask you, can Mr. Walls,
Yes, sir.
can we keep these things that you gave me earlier?
Yeah, I have tons of copies of everything. Yes, sir. So just for clarification, I don't need to remove anything before August 24th. The only thing I need to do is I need to go find some surveyor and pay him $500 to come out and do a whole new survey on the property, correct?
That's correct.
Yes, sir. Okay.
Okay, you're done.
Okay, thank you.
What are we doing right now? I'm sorry.
You can catch up if you don't want to. So let's go ahead.
We have one more case, so if we can,
Okay.
okay, Ms. Weavers,
Okay.
next case.
All right, our next case is going to be 21-325, which also had a previous case of 20-59. This is with Coastal Home Enterprises. The business is Coastal Defense LLC at 922 South 9th Street in Jacksonville Beach. This is in violation of prohibited signs, banner signs, and permit procedures. As you can see in the pictures, there were several signs that were observed at this business. There was a flutter flag that is not permitted. There is also a banner sign that is on the city right of way. We also had another sign on this bottom picture that was an unpermitted sign. The main sign that is in question and in violation today would be the banner sign that is repeatedly been put out after the business owner has been notified that this is a not permitted sign. This was in April 2020, also May of this year. You're going to see that the sign is still being placed out.
So is the violation for both the sign on that picture and
They're all listed the same.
the other one
Yes.
that you showed,
The-
the tall purple one, that one on the left?
The flutter flag has not been placed back out, but the banner sign is still out. As far as the sign that's on the building, I was just making reference that this was another unpermitted sign that was also placed on the building.
Has that been resolved through a permit?
No, it has not.
So you're saying there are how many signs that are in violation of the code?
There's actually two, because the one on the building doesn't have a permit, and then the banner sign.
Can those signs be permitted?
The banner sign, no. The banner sign is limited to 30 calendar days per year, and that's if there is a sale or if it was a new business owner that was opening up and they were like having a grand opening to some sort, then they would be able to put the banner out for 30 days.
And how many days has it been out?
This has been going on. This case was started back in March 19, 2020.
Okay. And is there a reason why it didn't get brought back sooner?
It came into compliance. The property owner did remove the banner sign,
Okay.
but from that point, we started doing code enforcement on the weekends, and our weekend inspector, David Martin, has brought to my attention that the banner was still being placed out.
And the
And that
sign
was
you're showing there has been out continuously?
pretty much what's been going on, is either after hours, or on the weekends that the sign is being placed out. Because this one from May was observed on the weekend.
Okay. And
The one from April, this was.
that sign could be permitted, but
No.
not the banner sign? Or, okay.
The one on the building can be permitted, but the banner sign cannot. The planning department recommendation is that if he wants a permanent sign out, he needs to apply for a permit for a monument sign.
Anything else?
Yes.
Okay. Okay. I don't have your name here, but I'm sure you're going to give it to me here in a second. So.
Yes, sir. David Dick. I own Coastal Defense and Coastal Home Enterprises, 922 9th Street South, Jacksonville Beach.
Okay.
All right, so let's talk about the signs. Go ahead and head back to your first visit of March 19th, about 1:30 p.m. So what you see here has been out. The bottom sign has been on my building since 2018. The flutter flag and the gun store sign have been out since 2017. This is something that I came to this chambers, to City Hall, to ask permission and had the code changed so that we could open a gun store. And at that time, the gun store was open Saturdays and Sundays 10 to 5. It hasn't changed through almost everything until we had a pandemic. So when the pandemic happened in March of 2020, I tried to help out the community and we opened Thursday, Friday, Saturday, Sunday. So I put my signs out Thursday, Friday, Saturday, Sunday. Now understand this has been going on since November of 2017. Miss Beavers came into my shop about 1:30 and attempted to extort my business and be given ammunition when we already had it listed as unavailable. She then informed me that she was a city employee and still wanted it. I told her no again. At that point, she said that she was code enforcement. I told her she still couldn't have the ammunition. At which point, when she came into my store, said nothing about my signs, nothing about my banners, nothing about my building. The only thing that she asked for when she came into my store was 9mm ammunition. When I told her no 3 times, at that point she told me my signs were in violation. So March 19th of 2020 would have been the very first time that I heard that we were in violation. This was so egregious that there was a firefighter in the store at the time that this happened. And I have a letter written by him about Ms. Beaver's conduct at my place of business. After she left, she pulled out of the parking lot, came back in, and then told me my signs were in violation for a second time. This is after she had threatened me, which is all written. We have this on video. I've posted the clips to YouTube. I've also submitted a complaint to the Office of the Inspector General for city employee misconduct, and I talked to George Knight, and this entire thing got dropped. That's why you see pictures from March of 2020 and nothing again for 12 months. For 12 months, nobody said anything to me. When I called George Knight on the 20th, because we were served our very first sign violations. It says March 19th on the top of the tags, but they didn't come into my store until the March 23rd, I believe. So March 23rd, I called George Knight and I said, George, what's going on? Tell me, I explained to him what happened. He said, we'll take care of it, don't worry about it. I said, what do I need to do? He said, take down the flutter flag. So we did. And that's it. And I've heard nothing for 12 months. On the 1-year anniversary of Miss Beavers trying to extort my gun store, she comes in with another violation. I answered that and I said, you know what? No, we're not going to do this. I want a hearing. I want to get up in front of somebody and find out what is going on. How come this is happening? Why is it that you don't say anything for 3 years? For 3 years, nothing's a problem until she tried to extort me, and I said no. After I said no, I called George. He said, take down the flutter flag. Said nothing about the other signs. We took down the flutter flag. 12 months goes by, nothing. On the 1-year anniversary, we got served again. So I asked for this hearing because I don't know, there's 67 pages of sign regulations in Jacksonville Beach. Now, the one on my building that you see on the bottom picture, that was all permitted when we did the original building. It's painted on the side of the building. It doesn't wave, it's not lit up, it's nothing. It's no different than the signs that are painted on the outside of my building. We painted my building in 2015, and nobody told me that we needed a permit for that. We built the pole barn. I have a permit from the city of Jacksonville Beach. We worked on it for about a year and had to stop because we had a client short us $150,000. So we stopped the construction on the building even though we had an active permit. They told me I'll just re-permit it when we decide to move forward. But that pole barn was permitted. That sign on the bottom is painted just like it is on my building. So I'm standing here today because if I need to do something, I need to know what it is, and I need to not be extorted by a city employee.
All right, let me understand I think you said, and maybe I misunderstood you, that on the picture here, there is, I'm not sure if it's concrete block, the 1-story building at the front?
Yes, concrete block.
Okay.
And it's painted.
Did you tell me that that sign was permitted or just that the building was
The
permitted?
building was permitted.
Okay.
And when we painted the building in 2015, we painted the green and the white stripe and we painted the coastal on it. So we never permitted painting my building because if you read the sign regulations of Jacksonville Beach, it says that you can paint the building. So we did. When we did the pole barn, we did the same thing.
Hold on 1 second.
Yes, sir.
One at a time here. So that lower sign was put there in 2015, did you
Yes,
say?
sir.
Okay, and the pole barn was built when?
2017.
And when it was permitted, the permit was for the building,
Yes.
not for the sign?
Good. It's what constitutes a sign? Is it because it's painted and has letters, is that a sign? If that's the case, then no, we did not permit anything additional for that.
And that was my question.
Yes.
The lighting that's on the side of the pole barn, that wasn't separate?
We permitted the construction of the pole barn. We did not submit anything about lettering on the pole barn.
Now, what about the street sign, the one that says gun store?
So the one that says gun store, again, has been there since 2017. And I set it out Saturday morning at 10 o'clock, and I pick it up Saturday evening at 5 o'clock. Same thing on Sunday, 10 to 5. It's been there since 2017. Now, after the April violation, April of 2021, I actually sent this to my counsel as well. And I said, what do I need to do? And what she told me was, she said, Dave, the best that I can figure is they're complaining about your sign being in the city right away. She said, can you put it in your yard? I said, absolutely. So we flipped it. If you go to the next set of pictures, you'll see that our sign is no longer in the city right away. It's in my parking lot, which, based on my counsel, was the correction for that.
What about the flutter flag? Is that gone?
When I talked to George Knight in 2020, we pulled it down. It hasn't been up since.
Okay.
Because George told me that was the issue, was the flutter flag. Everything else was dropped as soon as I moved that flutter flag.
Okay, anything else?
I just need to know what we're doing. 67 pages of sign regulations. That fit, it was fine for 3 years. And until this became an issue in 2020, we've never heard anything about it.
Okay. Ms. Beavers, I'll allow you to address the statement made. If you choose to, you don't have to. But what we're here for is whether the sign is required to have a permit or not. But there's accusations made, so if you want to.
Yes, and those accusations were investigated and were found not to be true. The video did not reflect what Mr. Dick is stating, so we're going to move forward and stick to what these violations are. As stated in section 34-458, as far as the banner sign, this states that, again, one temporary banner sign is allowed for new occupancy or use, or the size permitted for a permanent wall sign for such use, and a maximum of 30 days within the first 6 months of establishment of a new occupancy or use. A banner sign may not be illuminated. So, in regards to the banner sign, this is the ordinance that states that the banner sign, whether it's on the right-of-way or on his property, cannot be placed out.
And the banner sign is one that says guns and ammo.
Yes, the
rectangular.
banner sign would be this one.
And
As far as the permit procedures, that would be the sign that's actually on the building that was not permitted. And then for the violation in section 34-444, as far as the prohibited signs, this covers the part as far as this being placed out in the right of way. As you can see, on April 2020, when our weekend inspector was out, it was observed.
all right, you've heard Mr. Dick. Does it make a difference if he puts it on his own property?
I'm sorry.
Does it make any difference if he
It
puts the
does not
sign on
make a
his own
difference if the
property?
banner sign is on his property or on the right of way. It's not permitted after 30 days of a new establishment. Again, it's limited 30 days per calendar year. So if he's having a sale, he can put that out for 30 days, put a sign out saying, hey, grand sale or liquidation, whatever sign, but it would be limited to 30 days.
And insofar, let's back up a second. We go back to the photo of the building. With regard to the building, is it the painting on the pole barn or and/or depending on the building or both.
It's on the
are
barn,
permits.
it's on the pole barn, the top picture.
Does that have to do with where it's located or the size or,
It wasn't a permit issue for it to be there.
but any sign on the wall requires a permit, or does it have to be a certain size in order to?
Not clear on the one that's at the bottom because that was his original sign that he had down. But the one on the top, it wasn't a permit issue for that one. Because the one on the bottom would be the only sign that was actually for the business. He doesn't have a monument sign or anything that states that the business is there other than that one that was on the building, the lower building. Our inspector would also like to speak.
Okay, is that Mr. Martin?
Yes.
Okay, come on up, Mr. Martin.
David Martin. So to start off with about the building sign, there is a requirement on size. It has to be uniform when we go out and inspect signs once they're permitted. There is a requirement. Most of the time, it's signs along a building, and they all have to be uniform in size with each other. One can't be exponentially larger than another one. Since there's no other building around, I'm not exactly sure what the size of that can be, so we'd have to do a little bit more investigation on that. As far as the banner sign, the one on the right, not the flutter flag, the one on the right, I was unaware. I've been tasked with a weekend project to help with the sign issue in Jacksonville Beach, because there's a lot of bandit signs, there's a lot of flutter flags, there's a lot of unpermitted, unallowed things in Jacksonville Beach. So I've been tasked with going out on the weekends. I was unaware that Ms. Beavers had an issue with Mr. Dick. I think the attack on her character is insignificant.
We don't have to talk about
It's
that.
clouding the issue. The issue is when I drive by and I see this sign and I go report it, then I hear about the issue, but the sign was reported by me because it's out of compliance, and it is the same as I'm reporting everything else in Jacksonville Beach for the 8 square miles. I'm reporting all those signs, so when I drive by and I see a sign that's out of compliance, that's why I took a photo of it, that's why it's been reported. And it was actually done by me. It had nothing to do with Ms. Beavers. It was actually done by me.
Okay. Mr. Dick, do you have anything additional?
Yes, sir. What I'd like to do is I'd like to submit this into record.
Okay.
This is the letter from the firefighter who witnessed the incident at my store. He's
Okay.
the one he couldn't be here today, unfortunately, but he was going to come and report his version of events that were reported, and we actually had the police department involved, so there is a case on this.
All right, I'll accept this in the record without,
Without testimony.
well, no, without a determination that's relevant to whether
Correct.
a
Right,
violation
because the
occurred.
police department.
I mean, I don't see that it's relevant to whether
Well,
a
my
violation
question-
occurred or not.
My issue on the relevance was this, is after I filed a complaint, all of these things disappeared. We never got another notice. We never heard anything about it. Everything just went away. And it was kind of like, okay, you drop it, I'll drop it, and that's what it is. So the fact that Mr. Martin found it exactly 12 months later is just a heck of a coincidence. But it is what it is. If we need to get a permit, or we need to do a monument sign, just tell me, Dave, you need a monument sign and you need a permit. If that's the case, I'll get it tomorrow. It's not that big of a deal, but I just need somebody to say, look, you can't have this because of this, instead of all of these violation letters that don't actually specify what happened. They just say, here's a violation for a sign.
Okay.
So if we need a permit, A, tell me that I can have a permit, or that I can have a monument sign, and I'll go hire a company to come do it this week. I don't mind getting a permit if that's what the deal is, but unless I know there's an issue, and I asked for this because of the timing of everything.
Okay. Thank you, Mr. Dick.
Mr. Martin. So once again, the attack on the character is irrelevant. The signage was found in this time frame. This is when we just implemented this, what we call the Weekend Warrior program. So we haven't been doing this for that whole year. We just started this, and that's when I started driving around, and that's when I saw the sign. So that's why it was just found recently. Not that we waited a year to try to let something cool down, because there was, you know, we just started this program. That's when I saw it. That's when I reported it. That's why the timing is now.
And as stated earlier, Mr. Dick had came into compliance until, like he said, he opened up on Thursdays, Fridays, Saturday, and Sunday. These were during after hours, so I drive down 9th Street every day. The sign was not observed, so he had not been cited anymore because the sign had not been observed. So again, if you're putting the sign out after hours or on the weekend, it's not being seen. After, when the pandemic started, everybody was putting signs out, we're open, this, that, and the other, letting the community know that they've opened back up. So in order to get everybody back into compliance and to bring the signs back in, now that we're back at 100%, that's when we started the Weekend Warrior, trying to get everybody back into compliance about any signs that were being placed out. So
That doesn't account though for the large sign on the side of the wall?
No. This is as far as the banner sign.
Okay.
So being that Mr. Dick was caught putting the sign back out during the weekend hours that Mr. Martin observed it, he was notified just like anybody else would have been notified.
Right. Okay. What is the typical time frame that would be required to get permits for the two signs that we're talking about?
He would not be able to get a permit for the banner sign.
Well, to replace it with a monument sign.
Right. He would have to submit an application to our department. I'm not familiar with what those procedures are, what the time frame is with that. He would have, it would be planning and zoning. And he would just come to our office and state that he wants to apply for a monument sign permit. And they would let him know at that time what the time frame is and what the specifications as far as size and where it can be located.
Okay. Mr. Dick, you do need permits for those two signs. And if you want to do be able to have the banner sign or something equivalent out all the time, you need to get a monument sign permit for that.
If we can get a permit for a monument sign, I'm on board 100%.
Can you make an application within the next 30 days?
Yes.
Okay. All right. I'm going to enter an order finding that the property's in violation currently, the two signs that we're talking about, and that they require permitting, and give 30 days to file an application for the permit. And then, assuming that you make that application, then we will, hold any further action until we see whether those permits were issued. And the order will also require not displaying the banner sign except in compliance with the law, which apparently allows you 30 days.
30 days.
Which he is already.
Until such time as, either there's, let's just say that you can only use it in conformance with, those requirements.
Right, and so with this, he would not fall into those requirements for the banner sign because this is just advertising the business. But if he had a sign up that said he's having a sale or something to that sort, he would be allowed to put that type of sign up for 30 days, but not this one.
Okay, I got it. And Mr. Dick, again, as far as, the concern you've expressed, again, that's outside my bailiwick.
Understood. But that's why I asked to be here today, because of the timing of everything and what happened and transpired. So I need to file an application for planning and zoning for a monument sign.
And also the sign.
Is it
building sign.
the same permit application? Can I go, look, I got one on my building and I want a monument, or do I need two separate
It's
permits?
two separate permits.
They're the same, you go to the same place to get it.
Yes.
Right, but I wanted to be clear, if I just need one signed permit, and will it cover both, or do I need to go, hey, look, this is on my building, that the building's permitted already, but now I need to have a separate permit for the wording on the building, then so be it. I need to know where we're
Two
at.
separate signs.
And again, a quick phone call would have been much more convenient.
Okay, anything else?
No, sir.
Okay, I think we're done, Mr. Dick.
Thank you.
Thank you.
That
I think that concludes
Yes.
the hearings. We're just, hopefully we can get the stuff copied for you. Okay, we're adjourned.